car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
And welcome to the Attorneys, where legal expertise meets the community. And on this show, we're going to dive into the complexities of the rights of minors. I'm Art Franklin, your host. I also want to remind you that right now, lawyers at Hollis Wright, they're manning the phone to take your call at 1-844-LAW-TALK. That's 1-844-LAW-TALK. That call is free. That call is confidential, and they'll be taking your calls throughout the show. Let's go ahead and get into this topic on the rights of minors. As Carter Clay, it's been a while.
Good to see you, Art Franklin. How you doing?
Doing real good.
Good. Yeah, so we're going to do a show tonight on the rights of minors, and we're going to be covering some unique areas of the law that relate to those rights. We've had a lot of shows over the years that touch upon minors and legal rights associated with minors, but these are some unique areas that I think will be of interest, or I know will be of interest to the viewers, because how I came up with the show is that over 25 years of practicing law, we would get questions about minors from people that were very unique. And it may not necessarily have to do always with personal injury law, but it got me thinking about doing a show on this particular topic. And I think this is going to be of real value to a lot of the viewers. And we've got Davis Middlemas here with us this evening as a guest. Davis, thank you for being here with us.
Thank you very much, Carter. Happy to be here.
Yeah, and so Art, how I settled on Davis to talk about this topic is Davis and I recently worked on a case together. It was a personal injury case that I was handling, and as we'll talk further into the show, we got the case resolved, and as part of that process, Davis was appointed by the court to serve as a guardian ad litem, and we'll talk about what that means later on in the show. But I got to know Davis really well. Now, I knew Davis before he was appointed. We had worked with him on some cases over the years, but I really got to know him during this process and was very impressed with his knowledge of this particular area of law related to protecting minors' rights and settlement of personal injury cases. So whether he liked it or not, I said, Davis, you're the perfect guy to come on here and talk about this topic. So, Davis, thanks again for coming on.
No, thank you for having me. And it is an interesting topic. It's an important one because minors are treated differently than adults, and sometimes it can be a little bit confusing. So I think it's a helpful topic for the public.
Yeah, so before we actually get into the questions, just tell the viewers a little bit about yourself and your background and kind of what you do as a lawyer.
Yes, I've been practicing law here in Alabama for approximately, good Lord, 30 years now. So it's been a while. Several decades, and it's been entirely in the field of personal injury. I've represented plaintiffs and often minors, or minors along with their parents. And so the practice is I've done work injury litigation and car wreck litigation, but always helping personal injury victims, and have been pleased to know lawyers like the Hollis and Wright firm, who have been very helpful to me and very helpful to plaintiffs lawyers throughout the state of Alabama, and I'm pleased to be here on this topic today.
Well, thank you, and I really appreciate you helping me kind of develop these questions for the viewers. And so let's just kind of dive right into it. The first question that we've got is an interesting question because it's not something, honestly, that I ever really thought about in my own personal life, because I have children, and my children have complete access to their grandparents, and the grandparents have complete access to them. But we've gotten calls over the years from grandparents who may not have the best relationship with their own children, but they want access to their grandchildren. And so it got me thinking, well, what are a grandparent's rights to access and to have visitation with the grandchildren? And so that's the first question that we've got. Let's talk about that for a minute.
Yes, unfortunately, there can times be some tension between a parent and a grandparent about a visitation with a child. And historically in Alabama, there were really no rights for a grandparent to visit with a child. If a parent wanted to either block or limit access to a child, a grandparent really didn't have any recourse to be able to see that child. There were efforts made some years back to have a law that would allow grandparents to see their grandchildren, but it still had in place the right for the parent to block access if they wanted. However, back in 2016, there was a law passed called the Grandparent Visitation Act that allowed grandparents in certain narrow situations to try to appeal to the court or try to start an action to be able to visit with their grandchildren. Those narrow situations are the following. If parents are going through a divorce, or if the parents have died, or if there is an action in place to terminate the parental rights of the parents, then the grandparents can either initiate an action within those limited circumstances for visitation with their grandchildren, or they can join an action that may already be pending. For instance, if the Department of Human Resources has initiated an action to terminate the parental rights of parents, then perhaps the grandparents could intervene in that action to visit with their children. The court, when hearing an action brought under the Grandparent Visitation Act, they will try to determine and they'll try to balance the interest of the parent in guarding access to their children with the right of the grandparent to see the grandchildren and whether or not it would be in the child's best interest to have a relationship with the grandparent. So that was the purpose behind the law, was to try to balance those interests and to have some rights for grandparents to see those children.
Yeah, so really, Art, if you're faced with a situation where you're being denied access to your grandchildren and the grandchildren are being raised by two respectable individuals that are married, they can really terminate all access. You've got to fit it within those kind of 3 or 4 narrow exceptions, and then even then you've got to show to a court that it's within the best interest of the grandchild to have access or visitation with the grandparents. So I think that's a unique area because for somebody like me and probably all of us, we tend to take those things for granted, but there are a lot of situations out there where grandparents don't have the best relationships with their actual children.
And then even the children themselves, what are their rights? And if they don't want to see the grandchildren, does that come into play as well?
It may very well be. When the court is hearing a petition from a grandparent to see a grandchild, certainly the court would hear evidence as to whether or not the child wanted to see the grandparents. That would be part of the process in determining whether it was in the best interest of the child to do so.
Yeah, and a lot of that fundamentally comes down to the age of the grandchild. Obviously, as if you're dealing with a 16 or 17-year-old or 13, 14-year-old, the court's going to look to their wishes more than if you're dealing with a 3 or 4-year-old.
Absolutely.
Yeah. All right, let's shift gears. Restaurants. We all go to restaurants, and what are the minor's rights to be able to work in a restaurant, and can a minor serve alcohol?
All right. Well, first of all, a minor cannot serve alcohol. So the drinking age in Alabama, as we all know, is 21 years old. Now, we've all gone to restaurants where we are served. We have a server or somebody taking our order that is clearly under the age of 19 as a minor. But you will notice that although they will take your order, they may bring your food to you, what they don't do is serve alcohol. So restaurants will have, they'll have different employees doing different things. They'll make sure they limit minors to doing jobs such as cooking or bussing tables or taking orders. But if alcohol is going to be served, you will be served by someone of legal age of 21 years old. Yeah, that remains the law in Alabama.
You know, this whole idea about restaurants has always been one that caught my attention. I'm sitting at a sports bar. Yeah. A family comes up, they've got minors with them, and then they all sit down at the bar. Is there an issue with minors being even sitting at a bar?
There are restrictions on that. I mean, technically, they're not supposed to have minors sitting at a bar where they serve alcohol, and they're supposed to tell them that they're not really allowed to do out there. But I have found that there is some I don't want to say flexibility in the law, but flexibility perhaps within the restaurants in terms of allowing that to happen.
Yes.
Obviously, it's designed to prevent the service of alcohol, but if you're not serving the minor alcohol, it's kind of one of those, what's the big deal? But yeah, technically, I think
that's right. I think they know the law, but they try not to make a scene at the restaurant on those kinds of issues. Generally speaking, this actually is an important issue. There's a certain type of action, a personal injury action called a dram shop action, and if they are allowing, if a restaurant or bar overserves someone and those persons serving are under the age of 21, often that can be an evidence in this type of action. So this is a kind of an unusual area of the law, but can be an important important part of evidence in dram shop action.
I know we're going to
Yeah,
commercial break, but we're just getting started here. We've got a lot more to cover, and I think you're going to really enjoy these questions tonight.
A lot more indeed, but as we head to break, I want to remind you again that lawyers at Hollis Wright are standing by right now to take your call. That number is 1-844-LAW-TALK. 1-844-LAW-TALK is a free confidential call. You can also follow Hollis Wright on all the social media platforms, on Facebook, on Instagram, on X, and be sure to follow, share, and like the different comments that you see there. A lot of good information there as well. We've got a lot more to talk about on rights of children, the rights of minors, when we continue here on The Attorneys.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best: help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Hollis Wright has been handling workplace injury cases for years. If you've been injured on the job, give us a call. Our attorneys are standing by right now to give you a free consultation. And remember, at Hollis Wright, your result matters.
And welcome back into The Attorneys, where your legal matters matter to us. So in this edition of The Attorneys, we are discussing the rights of minors. And we got off to a great start. I mean, we dove right in, and it just continued on because there's so much to talk about on this topic, Carter.
Yeah, absolutely. And one of the areas that we confront all the time in our practice is related to settling cases, personal injury cases on behalf of minors. There's a completely different process that you have to go through than you do with adults. So if you settle a case on behalf of an adult, it's just a matter of signing a settlement and release agreement, which is a legal document to complete the settlement. But with minors, you have to go through the court, you have to get court approval. And we've actually got a viewer question here on that very topic. It says, I just settled an injury lawsuit for my child, and we have a court hearing soon. My lawyer tells me that the court likely will not give me much, if any, of the money to take care of my child. Is this correct?
Yeah, well, it's when, just as you said, the law treats settlements for minors different than they treat it for adults. Adults, you can simply sign the releases and you can exchange whatever settlement funds are going to be exchanged, and the court has limited involvement. For a minor, the court takes an interest to make sure it's in the best interest of the child who's settling the case. Often parents want to know whether or not they can obtain some of the funds, not for their own use, but simply for helping with the health, support, educational costs of raising their children. It's a very reasonable question often, but the law generally has been very strict that the funds that the settlement for the minor should be dedicated strictly to the minor. However, there are provisions under the law that allow some of the funds to be provided to a guardian or to a custodial parent in certain situations. One of them is called the Facility of Payment Act. And what that law provides is that money owed to a minor, at times a portion can be paid to a custodial parent or to a guardian if it's in a limited amount. That limited amount under the Facility of Payment Act is $5,000 if you're going to pay it in one lump sum. It has a differing provision that allows what's called a series of payments. If you don't want to do it in a lump sum, you could potentially pay it out in a series of payments with it not being more than $3,000 in any one given year, and then capped out at no more than $25,000 over the whole period of time that the child is a minor until the child reaches the age of 19. Right. So that allows for some help to the parents who maybe need some assistance in providing for the education or support for their children. This Facilities of Payment Act can be coupled with a structured settlement. I know that the Hollis and Wright firm is involved in this from time to time. And so, for instance, if you have a settlement for a minor that's approximately, say, $200,000, perhaps there's been a serious injury to a minor, you can set up a structured settlement that follows along with the provisions of the Facility of Payment Act, where perhaps over the time of that the child is a minor can be paid out in $3,000 increments, and then amounts paid, the balance paid once the child reaches the age of majority. Also in a structured settlement, as long as we're talking about that, you can set up a structure where no money is paid to the minor during the time that they're a child. The structure simply would, the money would be invested, it would gain interest, and then would be paid out in whatever sorts of increments after the child reaches the age of majority. Now, that doesn't solve the issue of what our questioner had here, which is when they need help with raising the child and the cost of educating the child and that sort of thing. Another part of the law that might be of assistance in that is called the Uniform Transfers to Minors Act. People traditionally think of the Transfers to Minors Act and that they think of it during estate planning. Perhaps you want to have something go to a child or go to someone who's not yet an adult, and the Uniform Transfers to Minors Act is used for that. But the language of the Act specifically makes provisions for when a settlement to a child occurs. And so you can use that act for payment to a custodial parent, to someone having legal custody of the child. And those provisions are that you can pay it out in no more than $10,000, although it was traditionally $10,000. Recently it has been up to $50,000, and that amount can be paid out to the child and used for the health support and welfare of the child. And then if there's any other left, it can be coupled with the Facilities of Payment Act, or you can pay out the balance once the child reaches the age of majority.
Yeah, Art, that was an excellent explanation, but as you can tell, this can get complicated.
It can.
But the bottom line is, for parents who are settling cases on behalf of minor children, the parents just need to understand that there's going to be a process they're going to have to go through, and that it's highly unlikely that the parents are going to get their hands on all of the money or much of the money that goes to the minor child. The judge will assess and evaluate all of the pros and cons of providing the parents money for the child's health, welfare, and education at that point in time, and they're just going to act in the best interest. But the court is going to be very restrictive on paying that money out to parents in a general sense.
And Davis mentioned something as I was listening to him. You used the phrase the age of majority.
Yes.
If you can explain what the age of majority is in Alabama, and even if a minor can enter into a contract.
Yes. The age of majority in Alabama is 19 and not 18. The reason I say that is many states it's 18. Now, although the age of majority in Alabama is 19, if it conflicts with federal law, such as the age to vote, is 18, federal law would control in that case. But in Alabama, the age of majority is 19. Now, traditionally, minors have not been able to contract, that you had to be of the age of majority to enter into a binding contract. Just recently, however, we've had a law passed in 2019 that said if a person is 18 years old and of sound mind, and otherwise an unemancipated minor, they can enter into a contract it would be held to be enforceable, and they could not repudiate that contract simply because they had not reached the age of 19. So that's a little crack and a little change in the strict law that only adults can contract. And so I hope that answers your question.
We've got a little bit of time left going into the commercial break, on the back end of the commercial break,
Right.
but we've got a lot more to cover, a lot more interesting topics.
Obviously, David Middlemas has a lot to tell us about, and that's why you're tuning into the attorneys, because this is where you get your valuable information, insights on the legalities of the law and the complexities of the law. We break it down and make it more easy for you to understand. We're going to take a break, but we want to remind you, though, you can reach an attorney. They're still answering the calls right now at 1-844-LAW-TALK. You can reach someone from Hollis Wright right now. It's a free call. It's confidential. All you got to do is make the call. Stick with us. We got a little more to talk about on knowing the rights of minors. We'll be back after this.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon. At Hollis Wright, we pride ourselves on having a bedside manner that's second to none. That means we listen more than we speak, and we return calls to current and potential clients. Our attorneys are standing by right now. At Hollis Wright, your result matters.
And welcome back. You are watching The Attorneys. I want to invite you to follow Hollis Wright on all social media platforms, on Facebook, on Twitter, which is now known as X, also on Instagram. And also make sure you subscribe and follow us on those social media platforms. There are also a couple of numbers scrolling at the bottom of your screen. You can use those numbers. We're making it very easy for you to get in contact with Hollis Wright. You can text one of those numbers and reach someone at Hollis Wright right now. Of course, you can call at 1-844-LAW-TALK. There are an attorney from Hollis Wright standing by right now to take your call, and it's free and it's confidential. The discussion today is on the rights of minors, a lot more to get into.
Yeah, and this next question is one that I almost took off because I did not want to encourage any of the minors to do this, but the next question is, can a minor legally get married?
Wow. That's a big one.
That's a big one, probably one fraught with some emotion. But the answer is yes, under certain circumstances. A child that's 18 years old, and that's not the age of majority, a child that's 18 years old can marry in Alabama. The law says that if a child is under 16, they cannot contract marriage. There is a little hybrid for when you are not 16 but not yet 18. So that period of time of 16 and 17-year-olds, they can petition to be married and if they have the consent of their parent or guardian. So the law does allow, generally speaking, only adults can marry, although you have those exceptions. An 18-year-old can marry. If someone under 16, they cannot contract marriage. 16 to 17, with the consent of the parent, filed by an affidavit or something with the probate court where they're going to get married, it could be allowed in Alabama.
Yeah, so this is one of those areas. I want to be clear. Nobody on the attorneys is encouraging anybody 16 or 17 or 18 to get married. I think it's probably a bad idea, and you probably should wait. And so it's probably one of those times where I would say to the viewers, if your child, or 16-year-old, asks if they can get married, you're still okay to say just no, you cannot, and move on, right?
The parental side of Carter Clay. We're going to kind of do these in fast fashion here now. But I want to ask you this question. Are minors allowed to make medical or health care decisions, very important as well, by themselves?
It is. 14 years old and older, they can. They have a right for any valid medical procedure. They have the right to consent to that. And also, part of that is release of their health information, a very big topic often. Any child 14 years or older must give written consent for a parent to see their medical information. So they don't have the full rights of adults, but after 14, they can control the medical decisions in their lives.
Yeah. Talk about how do minors file a lawsuit. We've talked about minors bringing personal injury actions, but can a minor file a lawsuit themselves? Can they hire a lawyer, and can a lawsuit be brought in the name of the minor?
A lawsuit cannot be brought in the minor's name alone. The law does make provisions for this, though. Under Rule 17C of the Alabama Rules of Civil Procedure, the court provides that a next friend, they call it, which is just an adult that's going to be acting on behalf of the minor, the lawsuit can be brought on behalf of the minor that way. Additionally, Alabama Code Section 65390 provides that a custodial parent, if the two parents are married, either the mother or the father, they can bring it on behalf of the child. If they don't have legal custody, the person that does have legal custody could bring it in the lawsuit for the child. So, unlike adults, you can't bring it, a minor can't just bring it on their own, but they can have a next friend or a custodial parent or a legal guardian do so.
Yeah, and this is where it gets really interesting, because we've had situations in the past where the parents got divorced. And when they have the divorce decree entered by the court, one of the aspects of the divorce decree will determine who has legal custody of the child. And sometimes the divorce decrees will say that the parents have joint legal custody. And so what oftentimes can happen in those situations is that if the minor gets injured, it oftentimes literally becomes a race to the courthouse. Because if they've got joint legal custody, then arguably both parents have an equal right to pursue the claim on behalf of the minor, and both parents can go hire their own lawyers, and sometimes the court looks at who filed the lawsuit first on behalf of the minor child. So that's one of those situations that can be sticky.
Yeah, and maybe this one can be answered pretty quickly, Davis. This is a situation in Alabama. Can a minor file to remove the status of being underage?
They can, but it's very, very limited. If a person is 18 years of age, they can petition, and they can have a parent petition to have the disabilities of non-age removed. There might very well be emergency situations where that's applicable, but it's that very limited window. You have to already be 18, and of course by 19 you're going to get to make all these decisions anyway. But you have to be 18 years of old, then petition a juvenile court to have non-age removed with a parent's consent.
Yeah. So. I think we've probably got time for one more question. Statute of limitations. Generally speaking, it's 2 years from the date of the incident. Do those statute of limitations laws also apply to minors?
They're different for minors. A statute of limitations law is the time in which a person has the right to commence a legal action. For instance, personal injury actions. Generally, that statute of limitations period is 2 years. You have from 2 years from when the event happened. For a minor, it differs in that their statute of limitations is delayed or tolled, we call it under the law, until they reach the age of 19. So, for instance, if a minor is hurt when they're 17 years old, they would arguably they will have 2 years after they turn 19 to bring the legal action, whereas we all as adults would have 2 years from the event. They have 2 years from the time they become an adult.
Yeah, in the medical malpractice realm, it's a little bit different. You don't quite have until you reach age 19. It's a little complicated, but you basically have 4 or 8 years from the time of the incident to bring a claim, depending upon how old you are when the claim arises. And so, like I said, we had a wealth of information to share with the viewers tonight. I think we're going to do this show again on the rights of minors, because there was a lot more to unpack here. There's a lot more in the materials that we had. Davis is an outstanding guest, and I want him to come back again and share some more information with us.
Absolutely. We knew that we would get a lot of information, and we did look forward to seeing you back here on The Attorneys. Also want to remind you that those attorneys are standing by still right now at 1-844-LAW-TALK. And you can reach one of the attorneys at Hollis, Wright. They'll answer your call. They'll get your information to you. It's free. It's confidential. We're so glad you joined us this week, and hope to see you back here next week. So long.
Thanks for watching The Attorneys, sponsored by Hollis, Wright.